Hello, everyone. In this recording, I want to talk about the corporate legal entity. And what we often hear is the company. So when we think about it, it's difficult for societies to progress without the idea of people and entities engaging in business. Some would say it is businesses that are the engine of industry. And so therefore, without the ability of companies such as Apple or even Toyota or Ford or Boeing and so on, we would not have the kind of products and the services that we see today. And when you speak about businesses, for example, it's not just a question of whether or not people are willing to put money into a business for it to operate, but you'd also have to think in terms of the potential liability when somebody wants to be in business. So in days past, if you recall, well, you probably will not recall, but if you look at history, the ones who typically own businesses or who engage in business were themselves the owners of the business, and they also ended up managing the company or managed their own business. So whoever was the owner of the company also ended up managing the business, but because the one who owns the company also runs the business, and therefore there was a huge investment in terms not just of money, but also of time and effort on the part of the owner. What then happens is that this particular owner who owns the business would find it very difficult, therefore, to manage other businesses. But that kind of situation is different today because you will often see people like, if you look at Bill Gates, who is the majority owner of Microsoft, or you probably look at Mark Zuckerberg, who is the majority owner of Facebook. Or you might look at Richard Branson, who is the majority owner, again, of the brand of the Virgin brand of companies. You will notice that these individuals actually have an ownership in various companies and various legal entities across the world. And the only reason why they're able to do that is because of the ownership of the company. Because using their money, they're then able to buy shares in particular companies or what is known as corporations in the United States. And so therefore, we see that with the idea of a company, we have enabled individuals to be able to widely disperse their ownership in business entities. But at the same time, it raises the question that if one becomes an owner of a business, does it mean that you risk having the debts of the companies you invest in become your own? So remember, in days past, when somebody owned a business, so in other words, perhaps in the 1600s, if you went to a small store, you would assume when you met the person who owns the business, you know that if that particular business failed, and that business failed and also owed money to some other supplier, who probably supplied vegetables or supplied the meat. The suppliers of the veggies and the meats would run after the owner of the business, because what typically happens is that owning a business doesn't only mean enriching or being happy in terms of the financial rewards, but it also means that in the event of loss, you personally carry the burden of the loss. So if you examine the idea of businesses today, what then happens when a business fails? What happens about a business who borrows money from the bank or from other creditors? Does it mean that when that particular business fails, it is possible for the creditors to run after the owners of that business entity? And the answer to that is that it all depends on whether or not that particular business entity has a separate legal personality which is distinct from the owners, or whether or not they only have one single legal personality. In other words, whether or not that particular business entity, as far as the law is concerned, also has the same identity as its owners, whether you're talking of a sole trader or you're talking of a partnership. And so tonight, I'm sorry, not tonight, it's tonight as far as the recording goes. So in this particular lecture podcast, what I'd like to do is to talk about the idea of the corporate legal entity. And in doing so, after studying this topic, you should be able to understand and explain the factors that should be considered when choosing an appropriate legal structure for a business. Understand and explain the distinction between an unincorporated and an incorporated body. Understand the consequences that flow from incorporation of a business. identify, define, and explain the main features of the business structure of sole trader, partnership, joint venture, trust, franchise, and company, and the legal nature of private entities, particularly companies, and the corporate legal forms and the doctrine of the separate legal personality. So let's go back to what I initially talked about when I started this lecture podcast. We know that the advancement of society today is owed in large part to the fact that businesses have really fueled, economic growth and advancement of society. But for that to have happened, it would have meant that there were certain individuals whose wealth increased, and then they were able to use the money that they had or the assets that they had to invest in various other businesses. So, as I said, people like Richard Branson, Mark Zuckerberg, and Bill Gates have an ownership in various companies all over the world. And if you look at Donald Trump, it's the same thing. Donald Trump, as the United States president, owns various hotels and casinos and other entertainment companies in the United States, making him one of the multimillionaires in the United States. And these particular hotels or these casinos that he may end up owning, and even apartments and buildings that he owns, which carries the Trump brand, the only reason that he's able to do this is that he has been able to use, whatever money he has to buy shares into these various business entities. But again, it brings up the idea about risk, so that when a business, one of these business entities fails, will it mean that they can run after whoever own the business entity? And so it is therefore crucial for us to talk about later on, or we'll talk about in this lecture podcast, the idea of the doctrine of separate legal personality as well as the idea of a limited liability company. These are the crucial features of a company as we talk about today. So that's one. But at the same time, let's say you want to start a business, and so what you would like to do when you want to start a business is to make sure that while you may be able to reap the advantages of a business, making a windfall and becoming profitable, you also want to limit your liability in the event that your business fails. Because if you look at statistics, typically within the first 5 years, about 90% of businesses actually fail, and they get liquidated or they shut down their doors because they become unprofitable. And so therefore, if you were an entrepreneur, you want to make sure that you want to get into business, and yet you don't want to be saddled by the debts and liabilities of a business that you invest into in the event it fails. Because running a business, starting a business is extremely risky, as you ought to know. Now, at the same time, if you think that, if you want to be a startup entrepreneur, and you're always looking at the idea that you want to be able to limit your liability in a business entity that you invest into, then what it will mean is that you need to go through certain legal requirements for you to protect yourself. So one of which is, as we discussed later on, that you must operate a company. So you have to set up a company and operate it as a company. And what the major requirement is that you have to go to the ASIC to ensure that you are then in a position to operate a company. Because without the registration of your business entity as a company with the Australian Securities and Investment Corporation Commission, then you don't have a company under the eyes of the law. And so therefore, if you were to operate a business that is not a company, you and that business are one and the same. So that the assets of the company or of that business are yours, but the liabilities of that business are also yours. So if that business fails, any creditor can run after not only the assets of the business you're running, but your own private assets. So that can be tricky. But at the same time, because you require registration with the Australian Securities and Investments Commission for you to form a company, what it therefore means is that there are certain legal costs involved simply in setting it up. So imagine spending maybe $1,500 just to set up a company, probably having to talk to a lawyer to do that. It also requires time to, to set it up. You probably have to sign some papers and so on. And so maybe at the startup, you probably spend $3,000 alone trying to comply with the legal requirements of setting up a company. And then what if down the line, number one, what if you don't have too much money? You want to be in business, but you don't really have that much assets or much cash. But at the same time, imagine if, after trying to operate it, trying to run it for about a few months or a year, it shuts down. You would have been out of pocket by $3,000. So on the one hand, you want to be able to limit your liability by setting up a company, but at the same time, you have to consider the costs of setting up a business into a company. And not only that, as we see later on, when you run a company, there will be certain legal requirements like holding meetings and having a secretary and so on. So we're going to be talking about that. We will also examine the types of business structures. So we talk about sole trader. We'll focus on the sole trader. We'll focus on the partnership. We'll also look at the trust, the idea of trusts as a legal concept, as well as a company. So we're going to see the differences among these four very common business structures. And then once we do that, we will also examine them from the viewpoint of business ownership. What exactly is ownership? When you say that you are the owner of a business entity, what do you mean? When you say you are the owner of a company, what do you mean? So let's say if you talk about who is the owner of Facebook or who is the owner of Microsoft, is it really Mark Zuckerberg who is the owner of Facebook? And is it Bill Gates who is the owner of Microsoft? Or Richard Branson who is the owner of Virgin? So we will notice that it's actually more complicated than that. And we will realize that even when we speak of Facebook or Microsoft or Virgin, the Virgin brand of companies, we will notice that the people, the entrepreneurs who we typically associate to be the owners of these companies own no more than 10% of the shares of that particular company. So the idea, therefore, of ownership, as we now know, is not the same as ownership in the past. When you said that somebody owns the company, yeah, probably owns it 100% or at least 90%. But today, when you speak of the large publicly listed companies, even the banks, whether it's Commonwealth Bank or ANZ or Qantas, when you speak of ownership, it's very difficult to see a single individual owning perhaps more than 5% of the shares of that particular company. So when you speak of ownership, therefore, it's quite different because the ownership of shares is very dispersed. And we will also talk about the effect of having debts and liabilities in terms of business ownership and tax implications, and what the legal effects are of a company. So let's begin by talking about the four common types of business structures: sole trader, partnership, trust, and company. Now, it is likely the case that you would have encountered various individuals, selling this and that or offering various services. So the common services that you'll probably encounter would be somebody who operates a mobile mechanic shop. So he probably comes to your home and does the fixing of your car or does the regular maintenance. You may encounter a carpenter. You may encounter somebody who would like to set up your metal pool railing. You might set up fences and so on. You may encounter somebody who's trying to who operates a bake shop, maybe a takeaway shop and so on. Okay. Now, you wonder, as far as these businesses are concerned, or these individuals are concerned, what type of business structure do they have? Is that a company? Is it a trust? Is it a partnership? Or is it a sole trader? And when you contrast that with a very huge business entity such as Qantas or Commonwealth Bank or Ford Motors or Holden, is it possible that these are run as sole traders? And the answer is obviously no. Because when the idea alone of a sole trader, single trader, it means that there's just one person running the show. You can't have it therefore in the big business entity. So typically, therefore, when you look at the big business entities, they run usually as companies. And we will get into greater detail what these are so. But the smaller ones, whether the takeaway shop or the laundromat that you encounter somewhere, or maybe even a coffee shop that you encounter somewhere, you don't know if it's a sole trader or it's a company. And we will examine why it is crucial to know the difference between the two. But what happens really is that when you're dealing with a sole trader, or when you're trying to set up a business structure as a sole trader, what you need to remember is that that sole trader as a business is one and the same as its owner. So if you have a business, if you're trying to set up a business and you run it as a sole trader, whatever assets are of that particular business as a sole trader are the assets of the owner as well. So if that business grows and it has $500,000 or $1 million in the bank, that belongs to the owner. No problem there. But on the other hand, if that particular business fails, what it would then mean is that the creditors of that sole trader will run after the assets of the owner of that business entity itself. So imagine that you're somebody with maybe $1 million in the bank, in your own personal cash, in cash, and in your own personal assets. And you want to be in business, and you're trying to operate maybe a small gift shop. And you want to run it as a sole trader because you want to avoid having to set up a company. It's too complicated to have books. So complicated to have to consult a lawyer about having the proper papers and so on. And so you run it as a sole trader company. And then you end up, because after a while you realize, oh, I don't have enough, I don't want to use my money. I don't have the cash. And so therefore I might borrow money from the bank. And you do. The bank, lends you money in the process. But what if your gift shop fails and owing, maybe $500,000, even $1 million to creditors? What can then happen is that all of these creditors can run after not only the assets of your business, but they can also run after your own assets, which means that in the event of a business failure, therefore, you can lose everything. Not just lose the business, but you lose your own personal assets. So that is something you need to talk about. But at the same time, when you look at it from the other side, if you're the other individual trying to deal with a sole trader, so let's say you want to have a house constructed, and certainly you're looking for a builder. And if you deal with companies that are huge in Queensland, for example, like GJ Homes or some other big building company, it is very possible that these building companies or construction companies end up charging you more to build a house. But then you're meeting with you've come across a builder who said, I can do it for you at maybe 30% the price, or maybe 80% or 70% of the price of what these huge companies provide. The danger there is that when you're dealing with a sole trader with a builder who is a sole trader, what if he doesn't really have enough money? When the business closes, you can't. It's so with the limited assets he has, you might end up losing everything. Typically, therefore, if you deal with a bigger company, the chances that they fail would actually also be less. So there are two ways of looking at it. The one, when you're operating it and when you're dealing with somebody else. Or in other words, would you be prepared to lend money to somebody who's running the show by himself, or would you be prepared to lend money, for example, or deal business with a company? So that's one question. The other business structure that is common is what is known as a partnership. And so if you speak of a sole trader, you say single individual, single trader. A partnership, therefore, you can't have a partnership of one. A partnership means there must at least be two, maybe three. So you can form a business partnership. In that case, again, you don't really have to register as a partnership with the Australian Securities and Investments Commission. And in that particular case, when you try to run a partnership, it's quite easy and inexpensive to set up. It would require a separate tax file number, though, with the Australian Taxation Office. But the problem there is that because it is run as a partnership and it is not a company under the law, what it means is that it does not have a separate legal entity. It doesn't have its own separate legal personality. It is not a separate legal entity, so that the partnership and the partners are one and the same. So if the partnership fails owing debts to creditors, the creditors can run after can run after the assets of the partnership, as well as the personal assets of the partners themselves. So in a sense, therefore, the sole trader and the partnership in terms of legal liability are almost the same, because there is no idea of limited legal liability. In other words, unlike when you speak of a company in a short while, because a company has a separate legal personality that is distinct from that of its owners. The owners, therefore, have a limited legal liability in the event a company fails. The other thing about a partnership is that what it means is that you're sharing, the control and management of your partnership with your business partners. So in the event that you decide to part ways because you've had disagreements, it might mean not only because you don't know how, you're having issues about how the business partnership should be run, or it might mean that the two partners end up fighting over something. It could be over golf. One has a better score, one cheated over golf, or cheated on a partner, whatever. If those two partners decide to part ways, the partnership has to be wound up and dissolved. So that's the problem with the partnership. So when you part ways on the basis of a partnership, the partnership has to disappear. Unlike, as we see later on, when you speak of a company, share owners come and go. You can leave a company and the company continues to go on because it has the idea of the right to perpetual succession. So we've talked about the partnership. The other business entity that you often hear is the idea of a trust. And the idea of a trust is quite common, and you'll probably hear those instances when, and these are in the instances when things become dodgy, where you have somebody who has been charged in court for defrauding a particular company, and they want to run after that individual who defrauded the company by running after his assets. And there are assets because it's living in a multi-million-dollar mansion. So, but he's saying, I cannot pay for my debts because I don't have any money. And then you say, but you're living in a multi-million-dollar house and you've got fantastic cars. How is it that you don't have you don't have any money? And it turns out that what often happens in these cases is that individual has actually transferred much of his assets to a trust. Okay, now that particular trust, in a sense, isn't really, it could be operated as a business, but what it essentially means is that the trust as a separate business structure of its own ends up owning the assets of certain individuals, and they will even have its own, it will even have its own trustee to manage the trust. And you can also form a trust in terms of, let's say, you have $1 million and you want to be able to make sure that your family is well taken care of if something happens to you. So you transfer funds to a trust so that even if when you die, it will be the trust that will manage the money that you put in the trust in behalf of whatever you decide in favor of the beneficiaries. So that could be a trust. So there are advantages to a trust. But that means that you require a formal trust deed, but it can also be very expensive to set up and very expensive to operate because you're operating it separately. So you can also have trust companies, I think, when it comes to some of these savings and loan associations. People put money in it, they form a trust. But again, what then happens is that if you operate a business as trust, it becomes the trustee who becomes legally responsible for its operations. And it's also possible for a trust to become a company itself. But the idea really is that when it comes to forming a trust, there will be some administrative requirements as far as it goes. Now, the most important business structure, and which is really quite common for those where a business has operated for some time, is actually the formation of what is known as a company. And for a business to become a company, it must have to be registered with the Australian Securities and Investment Commission. But not only is there a requirement of registration with the ASIC before a business entity becomes a company, it also means that there will be formal legal requirements that need to be complied with on a regular basis. Otherwise, the ASIC will revoke the registration of that business entity as a company. So I already initially alluded to some of the benefits of a company. Let's look at them now. So the key idea really is that a company has a separate legal personality. So if you set up a company registered with the Australian Securities and Investments Commission, what then happens is that the company has a legal personality that is separate and distinct from its owner. So in other words, when you look at the sole trader, you're dealing with a single individual putting up a business. When you deal with a partnership, you can talk about 2 or even 15. But because the partners typically operate it, it's so difficult to think of a partnership in terms of 100 or even 200. That happens. Like you have law firms ran as partnerships, accounting firms ran as partnerships. That's fine, but it just gets complicated because typically the partners themselves are running the business. Now, when you speak of a company, it is actually possible to distinguish between the ownership and the management of the company, so that because the goal of those who invest in a company is just to put their money in it and hope that there will be dividends and returns and the shares of stock, if it were to be a public company listed in the ASX, if the value of the market of the share goes up, then you generate the windfall. But when you invest in a company, whether you invest in stocks in Qantas, you invest in stocks in ANZ, you don't really plan on managing it, and neither will you be able to, because you only own a very small amount in terms of the ownership of the company. But the key idea there is that the company has a legal personality that is separate and distinct from its owners. So you can have a lot of individuals forming a company, they pool their money together, and once they've formed a company as registered with the ASIC, that company then has a legal life of its own. It's no longer possible that that company is one and the same as its owners. That company is distinct. And this, the idea of the doctrine of separate legal personality is tied to the case of Solomon versus Solomon Company Limited in 1897. And it is closely tied with the idea of limited legal liability. I had initially give you an example where you might have you might be dealing with a business. You might be a supplier to a company, and let's say you probably extend a line of credit to a company, maybe up to maybe 50,000, because you happen to be an electrician and you provide services as well as some goods in setting up something. So you've to a great extent, you've extended a line of credit to a company. The problem, however, is that what if that company shuts down? And when it does, you can only run after the assets of that company, but not of the owners of the company, because it is a company. But what happens then if that particular company has no assets? Or it may have assets, but it has more debts and liabilities versus its assets. So in other words, there's really nothing that you're going to run after. But you know that the owners of the company, meaning the shareholders, have assets. Can you run after them? The answer is no, because the very idea of having a company is, and because it has a separate legal personality, the key idea there is that the owners of the shares of a company have a limited legal liability, so that the liabilities of a company are not the liabilities of the owners or the shareholders of the company. In the same way, the assets of a company are not the assets of the shareholders. So even if you were the majority owner of a particular company, you cannot just say, oh, that car that belongs to the company because I am the majority owner, I'm going to use it, or that belongs to me. That's not correct. Or you cannot just use the money that is owned by the company, which is in a bank, and treat it like it is your own, and treat it like you have a piggy bank, which belongs in terms of whatever assets are owned by the company. That is not allowed by the law, because whatever assets and liabilities are owned by the company or belong to the company, they are not the assets and liabilities of the shareholders. So that is the idea of limited legal liability. The third key point about the nature of a company is that ownership is determined by shares. So that it's not even so much a question of how much money somebody invests in a company. So you can have an instance where somebody puts in, at the start of the business, maybe $1 million, and somebody only puts in $10,000. And then you say, oh, but I put in more money in the company, therefore I own more, I'm a majority owner. And before I give a particular example further, there's a case, for example, of the case of Facebook. Let's look at Facebook. So we know Mark Zuckerberg, but there is another owner. Trying to look at him now. Facebook Singapore owner. As it happens, I was surprised that there is another not so well known co-founder of Facebook. His name is Eduardo Saverin, and he is from South America, who's living now in Singapore. We don't really know Eduardo Saverin, but he is he initially invested money in Facebook, but at the same time, he was what some people would call to be an industrial partner. So what often happens is that when a business is put up, some people can put in money, some people can put in industry and their experience. Because you might have somebody who has a lot of money, but who doesn't have the business experience. You might have another one who has the business experience and business contacts, and they decide to put up a company together. But in that case, how do you determine ownership? Is it on the basis of the money invested? Is it on the basis of the industry? The answer is simply, at the end of the day, it's determined by the shares that the initial shareholders agree upon. So ownership in a company is determined by shares. So even if Mark Zuckerberg puts in $1 million and somebody puts in maybe $10,000, they may say that it's not, somebody doesn't own 100, the other one owns only one. They may even agree it's 50-50, meaning 50 shares for him, 50 shares for the other. So the ownership in a company is determined by shares issued and registered in the papers of the company. The other key idea about the legal nature of a company is that it has the right to sue on its own. So because the company has a separate legal personality in law, it is almost like a legal person with the right to sue. So therefore, if you engage in business, if you try to enter into a contract with a company and you fail to adhere to your obligation under the contract, that particular company can sue you. But at the same time, if there were a contractual arrangement between you and the company, you cannot run after the shareholders. You can only run after the company. So because it has a separate legal personality, focusing on the idea of a legal personality, it's like almost a legal person. The company is a legal person of its own. It has the right to sue and the right to be sued separately from the owners. The beauty of the company is that it also has the right of perpetual succession. So if you have a sole trader, if the sole trader dies, the sole tradership disappears because the owner is dead, the sole trader is dead. If one of the partners leaves, the business partners have disagreements, the other business partners will have to liquidate and wind down the partnership and maybe set up another one because there is no perpetual succession. But if you have a company, because of the idea of perpetual succession, individuals and companies that own shares in a company, they can move in and out. The company will go on because the owners of the shares are different from the company itself. And because a company has a legal personality, it also has the right to own assets. It also has the right to enter into debt. It obviously also has the right to enter into contracts. So you might wonder, does the company therefore, why would a company, if it's an artificial person and you don't even know who the owners are, because, and you know that the managers are not necessarily the owners. So if you go to Kohl's and you're dealing with the store manager there, is he the owner or not? I asked that question because I think it's quite common for Kohl's, to address their store manager as the owner. But is that ownership in the real legal sense? Can the the store manager, who might be considered owner, actually enter into a contract in behalf of Kohl's? And the answer is no, because as we later on see, what would then happen is that as far as in the next lecture podcast, we know that the corporate powers of a company actually belong to the board of directors. It is possible for the board of directors to delegate some of the corporate powers, such as the power to enter into contracts. But typically, you do not consider people down the line to have the power to enter into contracts. So it has to be the company that enters into contracts. And because the company is an artificial entity, it has to be individuals who have to sign contracts. But those individuals, or the set of individuals, typically would be the board of directors that does it. So we've discussed the company. We've talked about the separate legal personality that adheres to the company, the idea of limited legal liability, ownership determined by shares, the right to sue, perpetual succession, ownership of assets, the ability to enter into debt and liabilities, as well as to enter into contracts. Now, there are at least two types of companies. Some of them are private, and we often see that in the sense that the company will say PTY Limited. It says proprietary limited. It's proprietary. It is a company that is proprietary. The ownership, therefore, is divided into shares, and it is limited in the sense that we know that it has a separate legal personality distinct from whoever owns the shares of the company. But the crucial point is that if it is a private company, meaning it's proprietary and it is required by law, if it's going to be a private company, it's required by law to carry at the end of the name of the company PTY Limited or Proprietary Limited. What it means is that a private company is not permitted to seek in public new owners or new shareholders, or try to get the public to invest in the ownership of a private entity. That would not be permitted. If you want the public to invest shares in your company, like in a form of a public announcement, you need your company to be set up as a public company. And oftentimes, when you become a public company, you'd rather have yourself listed in the Australian Stock Exchange. So the advantage of having of being a public company is that it's possible for you to try to seek the public, go to the public, attract them to invest in your company, so that the company therefore becomes bigger and owns more assets because people invest in it. But if you are a private company, you can't make a public announcement seeking the public to buy shares into your company. That can't be done. So that's one of the limitations. The main problem, however, is that if you're running a company as a public company, it's going to be very expensive to do that because there are other legal and regulatory requirements. So our focus in the meantime is that if you were to be running a company, it will probably be in the sense that it's a private company, where you cannot make a public call for people to buy into your company. Now, the other point that we will often come across is the idea of the corporate veil, and you will often hear it in terms of the veil of corporate entity being pierced or the veil of corporate entity being lifted. Now, let's clarify that at the very start, it is not often the case that the corporate veil is pierced or lifted. So when you say, for example, that the veil of the corporate veil is being pierced, what happens then is that because of the piercing, legally, the idea of piercing the corporate veil, what it means is that when that veil, the corporate veil is pierced, the idea of a separate legal entity is pierced. What it means, therefore, is that the owners of the company are treated as the same as the company. They become one and the same. So the moment you pierce it, in a sense, the company disappears. What you are left with is the owners. So that if you pierce the corporate veil and the company is liable for certain debts and liabilities, then you can run after the shareholders of the company. That is called piercing the corporate veil. Now, on the other hand, what others would argue is that when you try to lift the corporate veil, what you attempt to do in doing so is that it's no longer just a question of trying to make the company and the owners one and the same. But what you're also trying to do is to make sure that you enable the shareholders themselves to try to act in behalf of the company. So remember we said that one of the effects of having a company is that the company is separate from the shareholders themselves. And so if somebody were to file suit in behalf of the company, it has to be the company, and it cannot be individual shareholders, not even the majority shareholder. So because corporate authority resides in the board of directors, it will be the board of directors who have the right to sue. But what if, let's assume that, a particular company has dealings with another company, and because they because of certain arrangements, it may be possible that the company is unwilling to take action against another one. What do the shareholders do? Sometimes what the shareholders can do is to try to lift the veil of corporate entity so that they can act in behalf of the company in perhaps undertaking legal action. But this hardly often happens. It's very seldom. It very seldom happens in common law countries where there's a piercing or lifting of the corporate veil. It can happen, however, in instances where you will come across instances where companies may engage in very egregious conduct. It has happened in the past where a company may engage in very hostile labor practices, which may mean that there have been instances when companies engaged, governments engaged paramilitary groups in South America or even in Africa to try to control a labor movement. And a lot of the labor union leaders or the laborers or whoever become part of the labor union, they end up becoming killed or being hurt in the process. And in that case, there have been instances when, because of the piercing of the corporate veil, it is possible that when the assets of a company are not that much, it is possible that somebody, especially in the part of the government, may try to run after the assets, not only of the company, but the assets of shareholders, if the shareholders themselves were aware of what is going on. So, or it could be that in the United States, for example, that the company has been used for the purpose of evading taxes, and there may be instances when the owners of a company, the owners of the shares, may become liable as well for certain tax liabilities because of the idea of piercing the corporate veil. But as I pointed out at the very start, it seldom happens that there is a piercing of the corporate veil. So finally, I said that there are certain costs in starting up a business as a company, because you need to register it as a company with the Australian Securities and Investments Commission, and you probably need to talk to a solicitor for that. But even if you've set up a company and it's now running as a company, there are then certain legal obligations. So the other thing you have to have in mind is that if you're running a company, you have certain legal obligation. One is that there must be an annual general meeting. You will also be required to lodge financial reports regardless of the level of your company's business activities. It also means you will be required to avoid certain transactions with related parties. So what it means, therefore, is that if you're operating a company, you cannot have a business transaction with directors of a company, because that will be a related party. So if you happen to be a majority owner of the company, it will be impermissible, without the approval of the rest of the board of directors, to try to transact with your own company. That will not be permissible, because that oftentimes these kinds of insider transactions are prohibited, because it can work to the detriment of the other shareholders in the company. And because what then happens is that oftentimes the directors, because they decide, they make policy decisions at the company, it is very possible for them to try to profit from their being directors. And in doing so, they may want, and of course they have insider knowledge about what the plans are of the company. They may enter into certain transactions or even contracts that personally benefit them. But if that happens, then it's actually to the detriment of the other shareholders of the company. So as far as one of the requirements of legal companies, that there will be certain transactions with related parties that will not be allowed. The other requirement is that there has to be 3 directors. When you speak, for example, of the public companies, whereas as far as proprietary companies are concerned, you can just have 1 director, and you need a secretary as well. Okay, so having said that, after going through this topic, you should then be able to understand and explain the factors that should be considered when choosing an appropriate legal structure for a business. Understand and explain the distinction between an unincorporated and an incorporated body. Understand the consequences that flow from incorporation of business structure. We also went through the main features of the business structures, the legal nature of private companies, particularly private entities, particular companies. And then we talked about the doctrine of legal personality and the idea of limited legal liability. So with that, I thank you for listening to this podcast. Thank you and bye.